Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content. Question number 1. 3 months ago, Bert agreed in writing to buy Sam's single-family residence, Live Acre, for $110,000. Bert paid Sam a $5,000 deposit to be applied to the purchase price. The contract stated that Sam had the right, at his option, to retain the deposit as liquidated damages in the event of Bert's default. The closing was to have taken place last week. 6 weeks ago, Bert was notified by his employer that he was to be transferred to another job 1,000 miles away. Bert immediately notified Sam that he could not close, and therefore he demanded the return of his $5,000. Sam refused, waited until after the contract closing date, listed with a broker, and then conveyed Live Acre for $108,000 to Connor, a purchaser found by the real estate broker. Connor paid with the full purchase price and immediately recorded his deed. Connor knew of the prior contract with Bert. In an appropriate action, Bert seeks to recover the $5,000 deposit from Sam. The most probable result will be that Sam, A, must return the $5,000 to Bert because Sam can no longer carry out his contract with Bert. B, must return the $5,000 to Bert because Bert was legally justified in not completing the contract. C, must return $3,000 to Bert because Sam's damages were only $2,000. Or D, may keep the $5,000 deposit because Bert breached the contract. Take 10 seconds and choose the best option now. If you chose option D, you'd be correct. May keep the $5,000 deposit because Bert breached the contract. To have a valid liquidated damages clause, the following must be in effect. 1. Damages must be difficult to ascertain. The damages must be a reasonable forecast, and the damages cannot operate as a penalty. In this case, the agreement between Bert and Sam for Bert to purchase Live Acre for $110,000. The contract stated that Sam had the right at his option to retain the $5,000 deposit as liquidated damages in the event of a default. The amount of damages in the case of Bert's breach would be difficult to ascertain, so a liquidated damages clause is appropriate as long as the damages do not operate as a penalty. $5,000 seems like a reasonable forecast of the damages that would have been incurred by Sam in the case of Bert's breach, so Sam may keep the deposit. Question number 2. Dell's sporting goods shop was burglarized by an escaped inmate from a nearby prison. The inmate stole the rifle and bullets from a locked cabinet. The burglar alarm at Dell's shop did not go off because Dell had negligently forgot to activate the alarm's motion detector. Shortly thereafter, the inmate used the rifle and ammunition stolen from Dell in a shooting spree that caused injury to several people, including Paula. If Paula sues Dell for the injury she suffered, will Paula prevail? A, yes, if Paula's injury would have been prevented had the motion detector been activated. B, yes, because Dell was negligent in failing to activate the motion detector. C, no, because the storage and sale of firearms and ammunition is not an abnormally dangerous activity. Or D, no, unless there is evidence of circumstances suggesting a high risk of theft and criminal use of firearms stocked by Dell. Take 10 seconds and choose the best option now. The best answer would be D, no, unless there is evidence of circumstances suggesting high risk of theft and criminal use of firearms stocked by Dell. To establish a prima facie case of negligence, the plaintiff must prove a duty, breach of that duty, causation, and damages. The basic standard of care is that of a reasonable person acting under like circumstances. In this case, Dell negligently forgot to activate the alarm's motion detector, but this would only be a breach of duty or a breach of reasonable care towards Paula if Dell knew or should have known that the theft in the area was common and that the rifle and bullets in the locked cabinet could result in harm to others. As such, Paula would not prevail in an action against Dell for the injury she suffered unless there was evidence of circumstances suggesting a high risk of theft and criminal use of the firearms that were stocked by Dell. Question number 3. Phillips bought a new rifle and wanted to try it out by doing some target shooting. He went out into the country to an area where he had previously hunted. Much to his surprise, he noticed that the area beyond the clearing contained several newly constructed houses that had not been there before. Between the houses, there was a small playground where several children were playing. Nevertheless, Phillips nailed a paper target to a tree and went to a point where the tree was between himself and the playground. He then fired several shots at the target. One of the shots missed the target and the tree and hit and killed one of the children in the playground. Phillips was convicted of murder. He appealed, contending that the evidence was not sufficient to support a conviction of murder. The appellate court should A. Affirm the conviction, as the evidence is sufficient to support a conviction of murder. B. Reverse the conviction and remand for a new trial, because the evidence is not sufficient for murder, but will support a conviction of voluntary manslaughter. C. Reverse the conviction and remand for a new trial, because the evidence is not sufficient for murder, but will support a conviction of involuntary manslaughter. Or D. Reverse the conviction and order the case dismissed, because the evidence is sufficient only for a finding of negligence, and negligence alone cannot support a criminal case. Take 10 seconds. You should have gotten this one. It's option A, affirm the conviction as the evidence is sufficient to support a conviction of murder. Under the common law, murder is the intentional killing of a person with malice aforethought. Malice aforethought requires that the killing be committed with one of the following states of mind: an intent to kill, an intent to commit great bodily harm, wanton and willful disregard, or intent to commit a felony. In this case, Phillips decided to do some target shooting, despite the fact that he realized that there was a small playground with several children were playing in the background. Despite being aware of this, Phillips chose to nail the paper target to a tree between himself and the playground, and then fired several shots at the target, one of which struck and killed one of the children in the playground. Phillips' actions clearly displayed a wanton and willful disregard of human life, so Phillips was properly convicted of murder. As such, the appellate court should affirm the conviction, as the evidence is sufficient to support a conviction of murder. Here the problem is relatively straightforward. As Phillips approaches the tree or the area, the clearing that he's used to hunting in, he sees the playground in the background and he opts to position himself to shoot from a location where the tree is directly in between himself and the children. He could have, in fact, simply turned around and faced the other direction so that his bullets were traveling in the direction opposite to the children. However, in doing so, and in aiming directly at the direction of the children, he is, as of course, arguably acting with wanton disregard for the children's safety. As such, A would be the correct answer. Question number 4. Retailer, a dry goods retailer, telephone manufacturer, a towel manufacturer, and offered to buy for $5 each, a minimum of 500 and a maximum of 1,000 large bath towels to be delivered in 30 days. Manufacturer orally accepted this offer and promptly sent the following letter to retailer, which retailer received 2 days later. This confirms our agreement today by telephone to sell you 500 large bath towels for 30-day delivery. Signed, manufacturer. 28 days later, manufacturer tendered to retailer 1,000, not 500, conforming bath towels, all of which retailer rejected because it had found a better price term from another supplier. Because of a glut in the towel market, manufacturer cannot resell the towels except at a loss. In a suit by manufacturer against retailer, which of the following will be the probable decision? A. Manufacturer can enforce a contract for 1,000 towels because retailer ordered and manufacturer tendered that quantity. B. Manufacturer can enforce a contract for 500 towels because manufacturer's letter of confirmation stated that quantity term. C. There is no enforceable agreement because retailer never signed a writing. Or D. There is no enforceable agreement because manufacturer's letter of confirmation did not state a price term. Take 10 seconds, choose the best answer. If you chose option B, you'd be correct. Manufacturer can enforce a contract for 500 towels because manufacturer's letter of confirmation stated that quantity term. A valid contract requires an offer and acceptance, consideration, and no defenses to formation. In a sale of goods contract, the quality of goods being offered must be certain or capable of being made certain. In this case, retailer offered to buy for $5 each, a minimum of $500 and a maximum of $5,000. Manufacturer accepted this offer and sent a letter of confirmation stating that 500 towels would be the quantity term for the contract. As such, manufacturer will prevail against retailer, but only for the 500 towels. Question number 5. 25% of the residents of Green City are members of minority racial groups. These residents are evenly distributed among the many different residential areas of the city. The 5 city council members of Green City are elected from 5 single-member electoral districts that are nearly equally populated. No candidate has ever been elected to the city council who was a member of a minority racial group. A group of citizens who are members of minority racial groups filed suit in federal district court seeking a declaratory judgment that the single-member districts in Green City are unconstitutional. They claim that the single-member districting system in that city diminishes the ability of voters who are members of minority racial groups to affect the outcome of city elections. They seek an order from the court forcing the city to adopt an at-large election system in which the 5 candidates with the greatest vote totals would be elected to the city council. No state or federal statutes are applicable to the resolution of this suit. Which of the following constitutional provisions provides the most obvious basis for plaintiff's claim in this suit? A, the 13th Amendment. B, the Due Process Clause of the 14th Amendment. C, the Privileges and Immunities Clause of the 14th Amendment. Or D, the 15th Amendment. Take 10 seconds and choose now. If you chose option D, the 15th Amendment, you'd be correct. The 15th Amendment protects eligible voters from discrimination in any state or federal election on the basis of race, color, or previous condition of servitude. Here, the group of citizens who are members of a minority racial groups are claiming that the single-member districting system is discriminating against minority racial groups because they cannot affect the outcome of city elections by voting. The 15th Amendment protects eligible voters like these minority racial groups from discrimination in Green City elections. Therefore, the 15th Amendment is the most obvious basis for plaintiff's claim in this suit. On to question number 6. Poole sued Durrell for unlawfully using Poole's idea for an animal robot as a character in Durrell's science fiction movie. Durrell admitted that he had received a model of an animal robot from Poole, but he denied that it had any substantial similarity to the movie character. After the model had been returned to Poole, Poole destroyed it. In order for Poole to testify to the appearance of the model, Poole must A, must show that he did not destroy the model in bad faith. B, must give advance notice of his intent to introduce the oral testimony. C, must introduce a photograph of the model if one exists. Or D, need to do one of the above because the best evidence rule applies only to writings, recordings, and photographs. Take 10 seconds. Correct answer is D. Need do none of the above because the best evidence rule applies only to writings, recordings, and photographs. The best evidence rule deals with the admissibility of writings. Writings are broadly defined as any tangible collection of data or information, such as videos, photos, x-rays, and computer disks, where a witness is testifying as to the contents of a writing, and those contents are in fact at issue. The best evidence rule requires that the writing be admitted into evidence unless it has been lost or destroyed, not due to any intentional misconduct of the party seeking to introduce the evidence. A witness is competent to testify regarding a fact if the witness observed the fact testified and must have a present recollection. In this case, Poole sued Durrell for unlawfully using Poole's idea for an animal robot as a character in Durrell's science fiction movie. The model of the animal robot is not available because Poole destroyed it. The best evidence rule does not apply here because a model is outside of its scope. Poole had personal knowledge of the model's appearance because it was his model. so Poole can testify as to its appearance. As such, the best answer option is that Poole needed to do none of the above because the best evidence rule applies to writings, recordings, and photographs, not to models. Question number 7. Abel was the owner of Blackacre, an undeveloped city lot. Abel and Baker executed a written document in which Abel agreed to sell Blackacre to Baker, and Baker agreed to buy Blackacre from Abel for $100,000. The document did not provide for any earnest money down payment. Abel recorded the document as authorized by statute. Abel orally gave Baker permission to park his car on Blackacre without charge prior to the closing. Thereafter, Baker frequently parked his car on Blackacre. Another property came on the market that Baker wanted more than Blackacre. Baker decided to try to escape any obligation to Abel. Baker had been told that contracts for the purchase and sale of real property required consideration and concluded that because he had made no earnest money down payment, he could refuse to close and not be liable. Baker notified Abel of his intention not to close and, in fact, did refuse to close on the date set for the closing. Abel brought an appropriate action to compel specific performance by Baker. If Abel wins, it is because A. Baker's use of Blackacre for parking constitutes part performance. B. General contract rules regarding consideration apply to real estate contracts. C. The doctrine of equitable conversion applies. Or D. The document was recorded. Take 10 seconds. Correct best answer would be B. General contract rules regarding consideration apply to real estate contracts. The rule is that a valid contract requires an offer that is accepted and supported by consideration. Consideration is the bargain for exchange of something of value. In this case, the facts clearly raise the issue of consideration, but the contract between Abel and Baker clearly has valid consideration. So Abel would win for this reason. The fact that the contract did not require a down payment is completely irrelevant. Don't forget, the contract did include a term and a price. The fact that there was a down payment or was not a down payment is actually not a requirement at law and is not necessitated as part of the consideration. Let's get on to question number 8. Peavy was walking peacefully along a public street when he encountered Darwin, whom he had never seen before. Without provocation or warning, Darwin picked up a rock and struck Peavy with it. It was later established that Darwin was mentally ill and suffered recurrent hallucinations. If Peavy asserts a claim against Darwin based on battery, which of the following, if supported by evidence, will be Darwin's best defense? A. Darwin did not understand that his act was wrongful. B. Darwin did not desire to cause harm to Peavy. C. Darwin did not know that he was striking a person. Or D. Darwin thought Peavy was about to attack him. Take 10 seconds. If you chose option C, you'd be correct. Darwin did not know that he was striking a person. Battery is the intentional infliction of a harmful or offensive contact with a victim's person. In this case, Darwin picked up a rock and struck Peavy with it. This is clearly an intentional infliction of a harmful or offensive contact, but the question is asking us to identify Darwin's best defense. A would not help Darwin because there's no requirement that he understand that his act was wrongful to be found liable for an intentional tort. B doesn't help us either, in that there's also no requirement that Darwin have the intent to cause harm to Peavy. C, on the other hand, would be a possible defense because battery requires a harmful or offensive contact with a victim's person. As such, not knowing that he was actually striking a person could be Darwin's best defense. D doesn't help because Darwin attacked Peavy without provocation or warning, and self-defense requires a reasonable belief of a genuine threat. Here, there wasn't sufficient time for that to formulate. So as a result, C is the best and only option that is correct. Question number 9. Suffering from painful and terminal cancer, Willa persuaded Harold, her husband, to kill her to end her misery. As they reminisced about their life together and reaffirmed their love for each other, Harold tried to discourage Willa from giving up. Willa insisted, however, and finally Harold held a gun to her head and killed her. The most serious degree of criminal homicide which Harold can legally be convicted is A. No degree of criminal homicide, B. Involuntary manslaughter, C. Voluntary manslaughter, or D. Murder. Take 10 seconds, choose the best option now. The correct answer is D. Murder. On the bar exam, every murder is second-degree murder unless you're specifically told otherwise. Second-degree murder, or common law murder, is the intentional killing of a person with malice aforethought. Malice aforethought exists if there is no excuse justifying the killing. No adequate provocation can be found, and if the killing is committed with one of the following states of mind: intent to kill, intent to commit great bodily injury, depraved heart killing, or intent to commit a felony. Here, Harold tried to discourage Willa from giving up, but Willa insisted, so Harold held a gun to her head and killed her. Harold had the specific intent to kill Willa in order to end her misery. There was no lawful excuse justifying the killing and no adequate provocation. Therefore, the most serious degree of criminal homicide which Harold can be legally convicted of is murder. And our final question of this grouping, question number 10. Buyer mailed a signed order to seller that read, "Please ship us 10,000 widgets at your current price." Seller received the order on January 7th, and that same day mailed to buyer a properly stamped address and signed letter stating that the order was accepted at seller's current price of $10 per widget. On January 8th, before receipt of seller's letter, buyer telephoned seller and said, "I hereby revoke my order." Seller protested, to no avail. Buyer received seller's letter on January 9th. Because of buyer's January 8th telephone message, seller never shipped the goods. Under the relevant and prevailing rules, is there a contract between buyer and seller as of January 10th? A. No, because the order was an offer that could be accepted only by shipping the goods, and the offer was effectively revoked before shipment. B. No, because buyer never effectively agreed to the $10 price term. C. Yes, because the order was, for a reasonable time, an irrevocable offer. Or D. Yes, because the order was an offer that seller effectively accepted before buyer attempted to revoke it. Take 10 seconds and choose the best option now. If you chose option D, you'd be correct, yes, because the order was an offer that seller effectively accepted before buyer attempted to revoke it. A valid contract requires offer, acceptance, consideration, and no defenses to formation. Under the UCC, an offer to buy goods can be accepted by a promise to ship the goods or by prompt shipment of conforming goods. The mailbox rule states that acceptance is generally effective upon dispatch. Here, seller received buyer's order on January 7th. Seller accepted buyer's offer by sending out a mailed acceptance letter on that same day. Seller's acceptance was effective upon dispatch. Buyer's attempt to revoke the offer on January 8th, but seller had already accepted buyer's offer. Therefore, there is a contract between buyer and seller as of January 10th because the order was an offer that seller effectively accepted before buyer attempted to revoke it. So as a result, there is a valid contract as of the day of shipment of the letter. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content.